Well, good morning, everyone. Thank you for joining us for today's webinar. The topic, avoiding the bully pulpit, best practices for creating an inclusive workplace free of bullying and intimidation. I'm presenting today. My name's Beth West. I'm a shareholder here at Weintraub Tobin, chair of the Labor and Employment Department, and I'm presenting with my colleague, another senior attorney in our department, Ryan Abernethy. We're really glad you could join us. I see the participant numbers slowly increasing, so I know that people are joining as we go. What we do experience sometimes when our behind the scenes administrator Ramona is letting these people in, that it sometimes freezes up our screen, so we'll try and deal with that, but hopefully everybody joins us. I just have a couple of introductory comments before we get started. We will be moving through the materials pretty quickly so that we can provide you with as much information as we can in the 1.5 hours that we have. We're not going to use the chat or raise hand functions today, just because we probably don't have time to deal with things as they come. But if you have questions, go ahead and put them in the Q&A, and if we have some time at the end, we'll respond. And then, of course, if we run out of time or don't get to your question, you can always reach out to Ryan or me. An e-blast went out before the webinar, providing you with a copy of the presentation along with information about applying for either HRCI credits or MCLE credits for the lawyers on the line. For those of you who may have registered late, there'll be another email blast that will go out after the PowerPoint, after the webinar, with the PowerPoint presentation and information on accessing the recording also of the webinar. And that email will also have some links to some other resources we provide, including our COVID-19 resource hub and our labor and employment blog, which we regularly post materials on when there's new developments in employment law. So with that, I'm going to turn it over to Ryan, and he's going to get started on the legal issues, some of the legal issues with respect to preventing violence and harassment in the workplace, go through what an employer's obligations are and so forth. And then later in the webinar, I'll talk to you about some of the research that is out there with respect to bias and cultural awareness that impacts potential bullying and harassment in the workplace. If I can get my slide to work. Okay.
Let's see if I have control here.
You should have control now, Ryan.
Great. Okay, well, thank you, Beth, and for the introduction. Like Beth mentioned, I'll be going through kind of some of the statutory and other legal obligations that employers have regarding workplace safety and bullying specifically, and how that kind of connects with some of our harassment prevention obligations and how those overlap, and help you kind of navigate those things. Okay, I understand I'm controlling. There we go. So to start, and as one would imagine, in Cal OSHA, right, where workplace, the physical safety of employees is mostly governed here by these statutes, OSHA and Cal OSHA. And just to start, I think it's important for us to realize that Cal OSHA has actually done some studies and just, looking at isolated events. And I've realized that over the last decade, the normal kind of fatalities and deaths and everything and injuries resulting from, kind of traditional OSHA violations and injuries caused by, contact with machines and slip and falls and things like that. Deaths and fatalities from those have actually decreased significantly over the last 10 years. Inversely, deaths resulting from assaults and other violent acts has significantly increased during that same time. So there's there's something going on, there's something in the water, right? And it's becoming a bigger issue in a lot of workplaces to know how to handle and respond to these really horrible experiences. This was surprising to me, I'm sure many of you as well, that there have been 37 workplace shootings since 2009. So under Cal OSHA, there's a general obligation that employers have the obligation to provide a safe and healthy workplace for the employees. And also that employers are required to take affirmative steps to prevent injury, illness, and violence, and must take certain steps to respond to the same. One of these, I call it the keystone obligation, is to write and prepare and to disseminate an effective injury and illness prevention plan, IIPP. And OSHA requires that certain elements be included within these IIPPs. And those include things like, assigning safety related responsibilities, right? Who does what in the event of, a workplace violence incident or other type of, safety issue. I'm not gonna go through all of them, but, and these are all available online. But, to establish a safety communication system with the employees, and to articulate a system for assuring employees compliance with the safe work practices, the manner in which accident investigations will take place, scheduling and evaluation of inspections, and things of that nature, as well as record keeping and documentation of incidents. And there's the model IIPP drafts. They're available through California's Department of Industrial Relations. So you could take a look at some of those as well. But I like to think of the IIPP kind of like the employee handbook for safety issues. It should be something that employers could go to so that when something happens, everyone knows where to turn and there's a uniform policy already in place that has been pre-planned, and people aren't scrambling to figure out to solve these problems. The next statutory regime that covers kind of this workplace safety issue is California Labor Code. This surprises some because usually this deals with wages and things like that. But under Labor Code section 6400, the employer has an obligation to furnish employment that is safe and healthy for the employees therein. So this is a separate, and standalone obligation in addition to OSHA's requirements. And under Labor Code section 6310, relatedly, an employer may not force an employee to work in an unsafe environment. In addition, that employers can't retaliate, including like discharge or discipline employee for making a complaint of an unsafe working condition, even if it turns out that it wasn't credible, for instance. So in case law, kind of that has been interpreting 6400 has further added some requirements that employers have to take reasonable steps to address credible threats of violence in the workplace. And we're going to talk more about how that can be done. And this is a particular labor code section that only pertains to the healthcare industry, hospitals. There, I think the legislature noticed that this industry was particularly being targeted by violent acts, typically I think from patients. But this labor code requires that these types of employers that they implement particular types of written workplace violence prevention plans with ways to manage and prevent healthcare workers from experiencing violence and to quickly stem it when you see the threats growing. Also, they have to obligation to create a violence incident log to provide specific training in the healthcare departments, and incident reporting, record keeping requirements, and the like. So there are specific warning signs that employers should be aware of when trying to assess, because it's a difficult thing, right? Usually, and it's not usually, but you can imagine often these things come and they're a bit of a surprise to everybody. I don't think any of those 37 horrible incidents of shooting, there might not have been a telltale sign of what was happening, but we'll go through and look at what OSHA has specifically identified, the Department of Labor specifically identified specific categories of workplace violence and, I guess, hallmarks and signs that employers can look for that usually forecast a workplace violence incident. But like I was saying, OSHA has categorized workplace violence to 3 different categories. And the first one is involves a violent person who has no relationship to the workplace. So they're a stranger of the workplace. And they're the ones who commit the violent act. Think of like a robbery, right? Someone just comes in off the street, or someone who really has nothing to do with the business. They're just there to cause this mayhem. And could also be someone who a family member of an employee or a ex-spouse or something who comes in to commit violence. Under this category, certain businesses are more exposed to this type of violence than others. And you can imagine some of these, like, there's been a lot of instances reported of like taxi cab drivers or with Uber drivers as well. Liquor stores, convenience stores, grocery stores and gas stations, bars, hotels and motels that are open late at night, movie store employees, security guards, and banks. All of these types of areas are exposed to a greater category of this type of risk. And so because of that, these businesses should, be making sure that they're focusing more on this and they have more protections in place for this category of risk. The second category, well, and going back to category one, a lot of, non-retail establishments and office places, and or industrial construction environments, this is a lot lower of a threat. You're not getting a lot of people there coming on the site. It's not really open to the public. It's a lot less of a threat. Category two, that OSHA defines here, is where the violent person is a customer or other user of the services provided by the business. It could also be a vendor. These are people who are expected and, almost invitees, if you will, to the place of work, up to the business location. They're not employees, but they're there, they come and go. And, this is former clients, customers, passengers, suspects, and patients. And then category three is where the violent person has an employment-related involvement with the business. These are the most closely tied to the employee-employer relationship. So we're going to talk again about the best practices in human relations that we can do to prevent specifically these types of, violent acts. So here's some warning signs that, again, the United States Department of Labor, really, they have this excellent publication on the issue of workplace violence. It's available online as well, but it provides a guide that can be used in judging workplace behavior and what to look for to predict and prevent workplace violence. And these are some of the, the lists, as well as others that, I think some are fairly obvious, if they deal directly with threats. Some are a little more surprising. But employees who demonstrate a large degree of inflexibility and constantly challenge management, they're kind of this all or nothing absolutist mentality. Those the DOL has found to be, are more likely to engage in violent acts. Overly argumentative employees, I don't know how surprising that is, but exhibits of paranoia, employees who are chronically disgruntled, employees who perceive malice or unfairness in others on a chronic level, and employees who track policy violations by others. Again, there's a lot of most employees who exhibit one or a few of these features aren't necessarily going to lash out, but these are all indicators to be aware of as the employer. And compulsive behavior, rocking, humming, things like that, where they seem a little disconnected from reality. Past history of violent acts. This dovetails with other webinars we've given about, background checks and criminal background checks and things like that. And so you should be aware of that. If you have any questions, make sure you know to what extent a violent criminal history could play into employment-based decisions. Other employees have a fascination, expressed interest and access to a weapon. Employees who are fascinated with other workplace incidents, violence incidents, they talk about them, or vindicating behavior. Employees who are constantly making kind of veiled threats, he will get his, or I'll make her pay for that. These are all the types of, and mostly not surprising, indicators of a potential threat in the workplace. The most, so we've covered what are some of the signs of this, but most category 3 acts of violence by employees, follow a triggering event. And these are, some of these triggering events. Again, obviously, if an employee has been fired, laid off, passed over for promotion, or suspended, that's going to trigger emotional response in violent employees, and they're more likely to lash out. That's where I think most workplace incidents occur, violence incidents. But also, other just a poor performance review, criticism from the boss or coworkers. Sometimes things outside of the workplace are what are the triggering event. Often someone's involved in like a ugly divorce battle, or a custody hearing just took place. There's other bank or court actions going on, foreclosures, bankruptcies, things of that nature, other restraining orders. These have all been linked to workplace incidents, and we're the kind of forecast for those. Other things like benchmark dates, as creepy as it sounds, there's increase in workplace violence acts for things like on Hitler's birthday and the date of the Oklahoma City bombing. This is on these employees' minds, and that's and it's acted out in violent manner sometimes. And again, kind of along the lines of extra work related issues, and impetus would be like a failed or spurned romance, or any number of personal crisis that employees might face, and they don't handle it the right way, and suddenly you're faced with a workplace violence incident. So we've talked about the indicators of the violence and the categories of the violence, and also the triggering events. So with all that in mind, employers have an obligation to kind of weigh these things and to regularly assess the risk of violence in the workplace. And this assessment could include knowledge of a research of prior violent acts in the workplace. I think that research primarily is sometimes a criminal background check. But if the employer knows or has reason to know about these things, there's some certain obligations that the employer would have to do something to prevent another incident in the workplace. Prior violent events in the surrounding area. So unfortunately, certain communities are more likely to have higher risks, and more violent acts occur. So that's something that the businesses should take into account when they're creating their plans and prevention assessments. Prior violent events in similar businesses and in the competition, like we mentioned, certain businesses are more likely to suffer violent acts in the various categories than others. Everyone talks about, right, the jilted post office worker, right? So there's certain industries people should be aware of. And understand that's maybe we need to be more worried about mental health than we have been. That's something else, not to tangent too much, but since COVID started, I've noticed in my own personal kind of advice and counseling practice, and I've talked to other attorneys in our office and outside, have noticed an uptick in almost like antisocial behavior. I think in COVID, a lot of people were so disconnected, and I think become a little people become a little hypersensitive on things, and with regards to politics and all sorts. And we'll talk a little more about some of these things later on. I think Beth will cover. But in the process, there's a lot more issues going on. There's a little more kind of mental health concerns in the workplace. So this is something that should be assessed. And if you notice this, the employer, it's in their power to help. It's something they should consider providing these types of services to help their employees and to prevent these types of interpersonal conflicts that seem to be increasing. Something else to consider is the factors of business operations, right? The different hours of operations that obviously if you're working late, you're more likely to have more incidents of, for instance, robberies versus if you're working 9 to 5 and that's when your doors are open. Offering physical security. Most workplaces might not need something like that, but if there has been repeated incidents, it might be incumbent upon the employer to provide an actual security guard. And that could be an employee or a third-party security service, but that's something that, might be required of the employer, and existing security safeguards. So these are all some things to consider, and there are many more. So regarding preventing and responding to threats of violence, and like I said, some of these threats of violence aren't always as clear as others. Some of them are, it's kind of on that line. Was this is a threat? I get a lot of calls trying to figure out and assess, how do we respond to this? What do we do? But the first step is obviously to train your employees on how to diffuse hostile situations involving clients, patients, customers, vendors, and members of the general public. So there's also to consider installing alarm systems or panic buttons in areas that are of particular concern. And we already mentioned hiring security personnel, but it might require you to call police about the potential violence. If it's imminent and if it's a concern like that, that's something, call the police department. That might be what's required by the employer. And update and apply the IIPP procedures. Again, like I mentioned, this should be the handbook and manual that you should always be able to refer to and utilize. OSHA requires it, but use that as an opportunity to get ahead of these problems before you're faced with them and you have everyone can hear me now. But again, enforce the no retaliation policy, meaning don't discourage employees from making these types of reports and complaints. Comply with all your reporting and recording requirements. Again, there's some that are generally applied to all California employers. Some are industry specific. Be aware of these. And the last one, which is obtain a temporary restraining orders as necessary. And I've had the pleasure of obtaining several, temporary restraining orders over the years. And, from these violent threats, sometimes it's a very clear threat. Other times it's just kind of unnerving activity, and sometimes that has been enough for us to be able to obtain a temporary restraining order against these employees or former employees. In one instance, I'm remembering there was an employee who was sending these text messages to his former manager, and this is at a restaurant. And he was sending, all these, like using chess jargon, checkmate, your move, just weird stuff, right? But it was enough to really put the employer on edge and to question, is my place, are my employees under threat? And we just took this collection of text messages, took it to the court, and had the witnesses testify, and we obtained a temporary restraining order there. And that employee was no longer allowed to contact anyone at the workplace, to come within a certain amount of yards within the workplace. They couldn't go to specific employees' homes. So this can be a very useful tool, again, for some of these threats. By the way, I think I saw we got some hands raised.
Ryan, can I just break in? They're having trouble hearing you. So I'm not sure if it's on your end, your microphone, but a number of people are saying that your sound is gone.
Oh, okay. Well, I hope that's any better there. I know I had a little internet issue there for a moment, which was odd, but hopefully That should be better now. Do you hear me a little better, Beth?
I can hear you, but a number of people have sent Q&A comments, and even internally here at the firm who are on said they couldn't hear you. So I have Ramona also checking it, but I wanted you to check your.
Gotcha. We'll see if that happens again. If we get any more reports, I think it might have. Okay, I can hear now. I'm seeing it's back on. So yeah, it was just that little glitch I had there with. So I think we're working again. Yeah. But anyway, going back to these temporary restraining orders, it's a very useful tool for employers and something you should always consider in these types of situations. Okay. Ramona, you want to give me access again here? There we go. Okay, so now we're going to move on to an employer's obligation to prevent and respond to harassment and discrimination under federal and state EEO laws. So if you think about this, you have these violent acts, which are, arguably the most kind of egregious type of workplace conduct you can imagine. But these are, you could call it the little sibling of these acts. This harassment in the workplace can sometimes, turn into actual acts of violence. And then we're going to talk about bullying, and it's kind of this pyramid, right? You could see how, bullying could turn into, unlawful harassment, and that can turn into workplace violence. And obviously today we're going to talk about, the main focus today is to prevent, workplace bullying and its implications. So here's some of the laws, and most of you should be familiar with this because now everyone gets our, sexual harassment training. But, all harassment of any kind and the discrimination in the workplace is governed by these types of statutes. You have Title VII, ADEA, ADA, and the Fair Employment Housing Act, which is the California equivalent of those, statutes. And all these statutes collectively prevent harassment, which is, targeted mistreatment of employees and coworkers based on their protected class. And again, I'm sure I'm preaching to the choir here, as most of you are probably aware of these, but this is a list of, many of the protected classes. And again, what this means is that decisions about employment and no workplace decision or mistreatment or anything can be based on someone's membership in these protected classes. Obviously things like race, color, national origin. Sometimes people are less familiar with, military status, genetic information. Mental or physical disability is a big issue and a growing issue here. A lot more lawsuits we're seeing in that regard. And some of the newer types of issues we're seeing are mistreatment based on someone's gender identity or gender expression, or their identification as someone who's transgender. There's two types of harassment. And again, this will somewhat cover issues you might have received in your sexual harassment trainings. But the first, to recap, the first type of harassment is this quid pro quo type harassment. And this is kind of old school harassment. We don't see a lot of lawsuits like this, but you can see how egregious it is, right? This is the type of where a supervisor or manager conditions an employment benefit or threatens adverse employment action based on an employee's compliance or refusal with sexual behavior. So quid pro quo means I give you this work benefit, or I'm going to withhold this work benefit unless you provide me with this sexual favor. We've seen a string of really egregious, highly public lawsuits and issues and allegations that have come out in the last few years, primarily through the Me Too movement, where this was basically the case. In certain industries, it's far more prevalent than others. But again, it's something that is, pretty obviously to most people, something that would be unlawful harassment. The second one, and I guess, which probably is a little bit more on topic with today, is the hostile work environment. And this is where a supervisor, coworker, or other individual at work, and they engage in unwelcomed or inappropriate conduct that is severe, pervasive, and creates an offensive work environment, interfering with employees' work performance. So this is, and the key word there is severe or pervasive. So there's some conduct that by itself wouldn't be enough to be considered unlawful harassment. But in totality, if it's pervasive enough and happens frequently enough, could become actionable unlawful harassment. And I mentioned previously, some severe acts of harassment can be severe enough that they're actually acts of violence, sexual violence or, abuse that includes, some sort of hitting or actual physical violence. So you could see how these relate, and how a harassment claim can easily parlay into and raise questions of an employer. How do we respond to this act of violence? And does this touch on our IIPP plan? So something to be aware of there. And from harassment, now bullying, which you could say is maybe the little sibling of harassment. And, we're going to talk about what it is it illegal, and how to recognize and respond to it. So the seminal case or seminal statute on this is California Assembly Bill 2053. And that went into effect back in January 1st, 2015. And this is the first statute in California that really defined abusive conduct or bullying conduct. And it defines bullying as any conduct of an employer or employee in the workplace with malice. We'll talk about that and what that means exactly. That a reasonable person would find hostile, offensive, and unrelated to employees' legitimate business interest. The key distinction there is unrelated to a legitimate business interest, because some things people might find offensive. They might find it subjectively offensive, but it's related to a legitimate business interest and isn't unreasonable given the circumstances. Things like a performance review, right? Things like or other types of legitimate employee discipline. It might not be welcomed, and someone might take offense at it, but it doesn't necessarily rise to the level of bullying. Malice is often the key distinction there. And for bullying and abusive conduct, here's an important distinction as well, is that conduct does not have to be based on protective status. So often when you hear harassment, you're trying to think, okay, is this related to someone's membership in a particular class? Bullying, it applies across the board and doesn't necessarily deal with someone's intent or targeting of a particular group. Okay, so here, and this is an important distinction between harassment and abusive conduct, is in California, unlawful and actionable conduct, harassment, discrimination, retaliation, all those things we mentioned under the previous statutes, the FEHA, Title VII, and the like. That is actually unlawful. Causes of action can be arise. You can, an employer can be sent to trial on those issues. Under AB 2053. It technically doesn't make abusive conduct unlawful or actionable conduct, but it does require that employers train employees on this type of issue. And again, it's defined. So abusive conduct, it's not unlawful or actionable unless it rises to the level of harassment, discrimination, or retaliation. So the statute specifically references and kind of gives examples of what abusive conduct might include. And this includes repeated infliction of verbal abuse, such as use of derogatory remarks, insults, and epithets, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining of a person's work performance. And if you notice what all these have in common are they're not related to a legitimate business interest. These are, basically targeting someone for whatever reason. You think about, this kind of self-evident bullying from your childhood that you witnessed or experienced, that It doesn't have anything to do with it's illegitimate, and a single act shall not constitute abusive conduct unless especially severe and egregious. So here's, again, some of these are self-evident. What does abusive conduct or bullying look like? We've just listed some specific examples here. Rumors is one that's very common in some workplaces, and employers need to do what they can to stop that from happening. Negative gossiping about other employees, pestering, spying, or intruding on one's private space. We're seeing that happen more often now, especially in this, increasingly internet cloud-based age, and social media, where this is becoming a bigger issue. Sometimes you have employees who are, pestering other employees outside the workplace, and that can become kind of an abusive type relationship, and they have to come and work with them. Yelling, screaming, or speaking in a harsh manner towards someone. This is something you see typically from management to employees, something to be aware of and to prevent. Consistently criticizing or belittling a person or their opinion, ostracizing or continuous silent treatment towards someone, unwarranted or unjustified punishment. And again, these are just examples that we've pulled. You could think of many others. I don't think they're going to be able to enumerate all of them. But unreasonable withholding information, discouraging ideas or initiative. I think HR professionals and other types of employers who act in that capacity, employees who act in that capacity, they often find themselves acting as kind of counselors and resolving these interpersonal conflicts, maybe sometimes to their surprise. And something that can be done in these instances, ways to remedy it, is to send kind of chronic workplace bullies to get training on how to better communicate, on how to handle these things better. That's something that's within the employer's power to do. And I've seen it sometimes to great effect, where these people are doing something some way. And if in the process, it can also increase, productivity in the workplace and prevents turnover in the workplace. So there's legitimate business interests as well as legal, reasons to, stem these types of issues. There's creates an environment in the workplace that's going to be more appealing towards, candidates and attract talent. So something to be aware of there. In addition, malice under AB 2053, which you mentioned earlier, is not actually defined. So but other statutes have defined malice. So we do have a little insight on how, it would be considered. But it's things like hatred, ill will, contempt. These are the words that courts have used to define malice in other statutes. And there is a fine line between abusive conduct and harassing or discriminatory conduct. Often it's indistinguishable. And it's, as an employer, you don't want to be in a situation where you're forced to say, no, this was just bullying conduct. This wasn't harassing conduct, because even if it technically wasn't targeting a protected category, that's not often going to prevent a lawsuit from being filed and sending that issue to a jury or a judge, for them to decide if it was because of my membership in a particular class, because often the only issue between bullying conduct and unlawful harassment is going to be what was in the head of the abuser, what was in the head of the bully, and you could see why that would often lead to, actionable conduct in lawsuits. And again, you don't want to be the employer that has to claim that what we call the equal opportunity harasser defense, which is probably the worst defense I'd ever have to make as an attorney defending one of these cases, which is that, oh, no, jury, he's just a jerk to everybody. He's mean to all the people. It's not the best defense to win over a jury or to have to make generally. So again, that's why this training comes in place and helps prevent, bullying turning into harassment and or turning into, violence or threats of violence. And Beth's going to talk more here about, how biases and cultural intolerance and power can often lead to bullying conduct. So, keep some of these concepts in mind as you're making these decisions, and to make sure you get out of this mindset of he or she is not a good fit. This is just the way things are done here. This person doesn't get our culture or work environment. They're just different from us, because often those are, the starting point to what can often become kind of bullying and harassment and hostile work environments contribute to that. And I think I'm going to pass the baton now over to Beth, and we'll see if we have time at the end to answer any questions. So Beth, we'll pass it over to you here.
Thank you, Ryan. And I should have control of the slides. We will see. I do. So Ryan just gave a summary overview of the legal obligations and the potential liability for employers if we have violence or threats of violence or harassment and discrimination in the workplace, and also an overview of what abusive conduct or bullying is under California law, which has to be trained on in the harassment prevention training that's required under the law. But a lot of open questions are, well, why do people bully? Usually when we're talking about abusive conduct and bullying, we think of children on the playground. And it's almost embarrassing that our state legislature had to come up with a bill that said teach adults in the workplace not to bully one another. But they did, because it happens. And I don't profess to be a social scientist. I'm a lawyer. But what I'm going to talk to you now is about a lot of the research out there that I have studied in connection with how bias, whether it's explicit or unconscious bias, can impact how we interact with one another in every encounter in our lives, but most particularly in our relationships with others in the workplace, and how sometimes that bias, whether we're aware of it or not, can result in us treating people a certain way that is deemed to be offensive or bullying, or worse yet, maybe harassing or threatening. And so with that, I just want to start and say, sometimes bullies are just aggressive, mean, manipulative people. They're people who have learned through their upbringing and socialization that aggression somehow means power and success. Sometimes they're people who have not learned to take responsibility for their role in a certain relationship or the consequences and outcomes of certain situations. And sometimes they're just people who don't realize or worse yet, don't even care about how their conduct impacts another person or a group of people in the workplace. So, starting with that, they can just be aggressive or manipulative people. And I wanted to just talk about this old parable. Most of you, or some of you, may have already heard it. It's called The Scorpion and the Frog. And this is just to illustrate what I'm talking about here, that, the scorpion is on the side of a river and sees a frog and says, "Hey, frog, will you give me a ride across the river?" And the frog says, "Well, why would I do that? How do I know you're not going to sting me?" And the scorpion says, "Well, why would I sting you? If I sting you, we're both going to drown and die." And so the frog says, "Oh, okay, well, that seems to make sense." And so he says, "Okay, I'll give you a ride across the river." And so the scorpion gets on the frog's back, and, they're in the middle of the river, and the scorpion stings the frog. And the frog says, "Well, why did you sting me?" And the frog says, "I just couldn't help myself. It's just in my nature to sting." So that is to illustrate that some bullies are just bullies. They just have been raised in a way, have had certain experiences where their way of relating to other people and the world is to be aggressive and or manipulative. But sometimes bullies aren't maybe aware of why they're bullying, and it can be caused by bias and cultural unawareness and intolerance. And so there's a lot of research out there, and I'm just going to summarize a little bit of it to try and help illustrate what it says. So the two main types of bias, there are lots of subcategories, But the two main categories are explicit bias, which is conscious. It's bias that we're aware we have, and then implicit bias, which is unconscious bias. And so when you look at explicit bias, there's a lot of isms, right? You can put an ism on the end of it: racism, sexism, ethnocentrism, and so forth. And if we are conscious that we carry those biases and we act on them, especially in the workplace, we are exposing ourselves and our employer to liability, because we know that we cannot mistreat people or make employment decisions based on our conscious bias of sexism, racism, and so forth. So these are really actually not the biases that are the hardest for us to get our heads around, because we know what the rules are and that we can't engage in this kind of conduct. It's these unconscious or implicit biases that are a little more difficult. And there's lots of research out there. Some people debunk it and say, oh, it's all hogwash. But there is a lot of good literature that supports the idea that we all have unconscious bias, that essentially we are hardwired based on many influences in our lives to react to certain situations and to certain people in a certain way, and to make pretty quick decisions so that we understand what we think is going on in our world around us. And this illustration I put up here, I really like, because I think it sums it up. We don't see things as they are, we see things as we are. And the reason why is because the studies show we get bombarded with, just tons of stimulus and data at one point, and our brains really cannot process it in real time all at once. So we have to fill in a lot to understand things. And when we do that, we're using our unconscious bias to fill in the missing links or to make sense of what's going on around us. And so when you read things like from the Kirwan Institute and some studies from Princeton, they outline where all these sources of unconscious bias come from. Some is just senses we have, right? We have a sense sometimes when we're interacting with someone, even if we don't really explore to verify whether that sense is accurate or not. But we have a certain reaction, comfort level, and sense when we're interacting with someone. More importantly, just our unique experiences, the family we were born into, the school we went to, the friends we socialized with, the city we grew up in, the state we grew up in, the country we grew up in, the church we went to, and so forth. They all influence our interactions with others. And then, of course, our values, right? Deeply held beliefs that we all have, they're different from one another. And they span many subjects: family life, religious, moral, and social beliefs. In today's very kind of politically heated environment, our political beliefs, right? We all have very deep rooted values in connection with those issues. And then our emotions influence us sometimes. Sometimes we're in control of them and sometimes we're not. And in the workplace, when we're under a lot of pressure or stress, those emotions may get away from us and we may act out towards others. And then, of course, self-interest. While we may not always want to admit it, oftentimes humans are driven by self-interest, and that can play a role in how we treat other people. Culture is similar to our values and our experiences. If we come from different cultures, and we live in the United States, so we are a very diverse country, and in California particularly so, with a lot of different cultures, that's going to influence how we see the world and how we see other people and interact with other people. And then, of course, the various levels of history, our own, our family, our organization or company that we work in, our community, and so forth. Religion, very much an influence in our belief system and our biases. And we'll talk a little bit when we get further into some best practices on preventing bullying about how in the world of the pandemic and COVID-19, the issue of individual freedom and religion has become very prominent again. I mean, as employment lawyers, we always knew that religion is a protected class, and it's one of those protected classes like disability that not only can we not discriminate on the basis of religion, but we have an affirmative duty under the statutes, federal and state statutes, to reasonably accommodate sincerely held religious beliefs if it doesn't create an undue hardship for the employer. This has been kind of a non-active protected class for the most part over a number of decades. There are some cases where religious accommodation or failure to accommodate claims have been filed, but there's not a huge body of case law on it. And we all anticipate now, because of the religious exemptions to vaccine requirements and other issues related to the pandemic, that we're going to see a lot more litigation in this area. And then the research shows that the other influence that all of us are subjected to, whether we recognize it or not, is the conventional wisdom, right? We live in a connected global universe right now. We carry around in the palm of our hand what we call a phone, but it's really a computer that connects us to the world 24/7, right? We can contact someone 24/7, we can research and get information 24/7, and there's a lot out there. And whether or not it's accurate or not is always open to debate. And so there's this influence of conventional wisdom where we say, well, of course, this is the way things are. Everyone knows that. Look at what's all over the internet. But unfortunately, we don't often take the time to research and evaluate the credibility or legitimacy of what we're relying on. So all of those sources and influences relate to the unconscious bias and kind of filtering that we walk around in the world in and rely on when we're interacting with others. So take that, whether you agree with it or not, and let's just talk about some biased beliefs that hopefully if I read them out loud and you read them on the screen, you'll recognize are biased stereotypes. Men are less emotional and smarter than women. Anyone over 60 is out of touch with technology and should not be hired in an IT position. A woman who dresses like a man and has a very short haircut is a lesbian. Hispanics are staunch Catholics and probably have too many kids. People from the Middle East are anti-American. An employee in a wheelchair doesn't work as hard as an employee who's not in a wheelchair, and women should be the primary providers of childcare. Now, as I read these out loud, I hope, I know we're not here so I can do, raise hands, maybe we could have, but I hope everyone will agree that those are stereotypes, they're generalizations, they're biases. Well, there's a study out of Princeton that says within a split second of seeing somebody or a picture of someone like I'm doing right here, our brain unconsciously is making a judgment as to who the person is, what they're about, and so forth within a split second. So for those of you who have never attended this webinar before with Ryan or me, when you saw our faces for the first time, within a split second, this Princeton study says, you've made a judgment call. It's called first impression, initial judgment, initial impression, as to who or what I am and what I'm about. And we do it all the time. And so while we may recognize when I read these statements that they are explicit biases, stereotypes, and generalizations, when we're seeing these pictures really quickly, our unconscious may be saying something similar to that. And we may not be aware of it. When we see this woman who has a short haircut and has a tie on, subconsciously, we may say, oh, that must be a lesbian. Now, we can't stop our unconscious self from doing what it does, but the problem comes when we start acting on some of those unconscious biases, right, to the detriment or damage of others. And so it's a very interesting study out of Princeton. If you're interested, I can get you more information. But what it says and others say is that we may know when we're really conscious and thinking about something, you know, whether or not we're being accurate and fair, but unconsciously we may be doing something that we don't realize is inaccurate or unfair. There's another kind of bias called confirmation bias or my side bias. And the theory under this type of bias is that we tend to favor information that confirms the bias or the beliefs or the values that we already hold to be true. And we do this, we seek information out, and we seek it from sources where it will confirm our beliefs. And in the 24/7 connectivity age that I said we live in, right, where we can access news and news channels, from very conservative news to very liberal news and kind of things, you know, channels in between, we seek out our news from a source that's going to confirm our beliefs, our biases, and our values on certain subjects. And there are two particular subjects in our culture and our society that we do this the most, according to the research. And we're just going to do one poll in today's webinar to see if you guys can guess what those two subjects are. And Ramona is going to launch that poll right now. Okay. Go ahead and register your response. Okay, we're just going to take a couple more seconds here for those who want to participate. Okay, I think we are, oh, we have a couple more people doing it. All right, we'll end the poll and I'm going to share the results with you. I think I can, I don't know if they're up, but the first one was the two subjects were climate and education. We had 9% of you responded there. Second, politics and religion. We had 86% of you respond there. And the third choice was family and finances, and we had 6% of you. Now, when you look at these choices, all of these subject matters are very important subject matters that we all have very strong beliefs about. So it's perfectly understandable for those who chose the first or the third category. But the research shows that statistically, confirmation or my side bias is most prevalent when we're talking about politics and religion. And, you know, again, we've gone through many years with a very volatile political atmosphere on a federal level in our country, both on who the administration was previously and who the administration is now, and then also living through an unprecedented pandemic. And this has resulted in politics and religion becoming very important subject matters in our society. And studies show when we're seeking out information, we seek it from sources that just confirm what we believe to be true, because it's too uncomfortable to seek it from a source that may challenge our beliefs. This unfortunately has resulted in some of the us versus them kind of mentality. And as Ryan and I can tell you, we've had clients who experience this seeping in to the workplace, where there is kind of a division and finger pointing and so forth. And we always have to be mindful that that can run the risk of bullying conduct, or worse yet, harassment and or threats of violence. Okay, there's another category of bias called in-group bias. And this theory of bias says that in in-group bias, we're compelled to favor people who are like us, right? That we're comfortable with, that we don't have to spend a lot of time figuring out who they are and where they come from. Well, this kind of in-group bias can, in the workplace, lead to discriminatory conduct, right? Where we have a tendency to hire and promote and provide better projects to and provide higher salaries to people who are like us versus people who are not like us. And there's many studies on this. I gave you the Panahi et al. Study here, but there are even more recent studies. And I often tell clients when they're talking to me about an employee that they're not sure they want to continue to employ, they will use the terms, he or she is not a good fit, or he or she is good fit. And I always say, you've got to put meat on that statement. There has to be context around that, because merely relying on a feeling that somebody is a good fit or is not a good fit is often being motivated by biases. And sometimes they may be biases that the person is aware of, but oftentimes it may be biases that they haven't really thought of. And it could be this in-group bias, right? They're not like me, right? They don't talk like me. They don't look like me. They're not the same gender as me. And if you just make a decision on good fit, bad fit, you are exposing yourself to potential liability if it can be established that you're motivated by an improper or illegal reason. Okay, finally, before we get off of bias, I just want to tell you guys about, last I checked, kind of the biggest implicit bias study that is out there. And it's out of Harvard and the University of Washington in Virginia. And you can actually participate in it. It's online. I gave you the website link here. And, you know, I put over 2 million people. It may be even a higher number now. But essentially what this study did or does is that participants in the study are asked to categorize or pair negative and positive or strong and weak words with different faces of individuals that are being presented to them. And the faces are of all kinds of people, African Americans, Caucasians, men, women, young, old. And the results overwhelmingly show that regardless of who the participant is, regardless of whether the participant is a man or a woman, is a minority, Caucasian, young or old, most participants, or an overwhelming majority of them, associate negative or weak words with elderly individuals, minorities, and women, and strong or positive words with younger people, Caucasians, and men, overwhelmingly. Now, is that because they've had the time, whether going through this program, to really analyze, you know, what they feel or know about a particular person who's being presented to them? No, it is hardwired unconscious bias, regardless of our gender, our age, and our ethnicity, where we are associating strength and positivity to a certain class or certain classes of people, and weakness and negativity to certain classes of people. And when we do that unconsciously, oftentimes without us knowing, it influences how we engage and interact with others. Okay, so let's jump into another area about cultural awareness and competency, because if we can try to recognize the biases that may be influencing us, we also have to recognize that when we're in the workplace, we are interacting with people from all different kinds of cultures and backgrounds who have individual differences as well as their cultural differences. And so we can't walk through the world and in our workplace thinking that everybody thinks the same way as we do, feels the same way we do, and so forth. So what is culture? Culture is the individual background or characteristic of each person or a particular group of people if they have a shared culture. Diversity is how people or groups are similar and different. And we live in a diverse environment, society, especially in California, and our workplaces are diverse. So cultural competency, which is the goal, is being able to recognize that there are cultural differences and then respect and work with diverse people and groups in the workplace, right? Recognize it, honor it, celebrate it, and be able to work together. And it's important for a number of reasons. As I said, the demographics in our society are ever evolving, right? We're very diverse. And so our workplaces reflect that diversity. And if we respect individual and cultural differences in the workplace, we're going to have better morale, more respect, and research shows that we're actually going to have a more creative and productive workforce, which will lead to less bullying, less harassment, and less threats of violence. So here's just an exercise, a self-reflection exercise. This is pulled from a lot of different areas, and I think it's helpful not for you to answer here today and know how you feel about these questions or statements, but to maybe spend some time in self-reflection evaluating these statements. I also say to people often when I'm doing some training is that, you know, unconscious bias cannot be addressed by saying, oh, I'm just not going to be unconsciously biased, right? And try to stuff it down, because we're not aware of it oftentimes. But there are some methods, some responses that we can utilize to try and get in touch with some of those unconscious biases. And I often say, you know, when you have a very awkward or aggressive or uncomfortable encounter with a person or a group of people, or even a reaction like that to a story about a group of people, maybe on the news or somewhere, take some time with yourself and question yourself, why are you reacting that way, right? What is it about that person, that group of people, what they said, what they did, how they talk? What is it that you believe is resulting in your reaction to them that way? And if you do some self-reflection like that, you may actually start to get in touch with some biases that you were not aware of otherwise. So I leave you with these to work on your own. But here is a really good graphic that I thought was helpful when it comes to effective cross-cultural communications, because if you look at some of the statements in the previous slide about whether you are aware of the issue of bias and whether you try to avoid stereotypes and you're open to learning about different cultures, this strategy for cross-cultural communication can be very helpful in the workplace, and it can reduce people feeling like they're not being included, they're being ostracized, or worse yet, being bullied, and so forth. So ask questions, right? I mean, show you're interested in people and their different perspectives. Distinguish perspectives, build self-awareness, avoid stereotypes, right? If you go into every situation and every encounter and apply your stereotypes, you're not going to have the cultural awareness that you need, and you are going to probably offend or intimidate certain people. Listen actively. You know, oftentimes when we're in a group with people, we want to be heard. We want to tell our version of something. We want to give our opinion. And so when we're listening to others, we're listening just to speak, right? We're waiting for them to shut up so that we can say what we want to say. Well, if we stop and realize we'll have our turn and actively listen to what people say, we actually may learn something. We actually may change an opinion or belief that we're holding and we're getting ready to articulate. And we also show respect for that person. Be honest, be flexible, think twice before you speak. And then, of course, this is really important. The issue of cultural awareness and communication is not only verbal, right? It's also nonverbal communication. Our gestures and posture when we're engaging with people, the tone of our voice, and so forth. There was a case many years ago that I defended, a wrongful termination case. And during the deposition of the manager who made the decision to terminate the employee, very genuinely said how frustrated he was with this employee and that she was terminated because of her refusal to take him seriously and look him in the eye when he spoke. And so he felt that she was blowing him off. Well, when you looked into the facts of the case and you understood who this plaintiff was, she was a young woman from Japanese descent, her background. Her parents were Japanese. She was brought to the US. English was her second language. And she was raised that it was disrespectful to look a man in the eye when he was speaking, especially an older man. And so she didn't look this gentleman in the eye when he spoke, especially during her performance evaluation meetings where she felt she was being reprimanded. Well, he miscommunicated that, or misunderstood it, right? So it was really an issue of miscommunication in which he thought she was ignoring him and disrespecting him. And so that's a very simple example of how truly just cultural differences resulted in two people interacting with each other differently and two people understanding the interaction differently. And so we've got to become aware of that if we're going to have an inclusive workplace, a workplace where people don't feel intimidated and bullying, and where we're not exposing ourselves and the employer to liability. So this is just kind of more the same with respect to that example, that we're often familiar with nonverbal clues of people who are like us, right? In that in-group bias group, people are like us, we kind of get their facial expressions, we get their gestures, and we understand them. But we may not understand body language from people from another culture, their facial expressions and mannerisms. So we have to remain open to that and not make judgments or reach conclusions as to what they do or don't mean, and be open to learning about it, right, and respecting it. Okay, so COVID-19 and bullying, we touched upon it just briefly, but here's where we find ourselves. And I will tell you that Ryan and myself and a number of our other colleagues, attorneys in the employment department, are dealing daily with COVID issues in the employment context, overlaying all the other employment issues that employers already deal with on a day-to-day basis, especially in California, where employment is so highly regulated. But right now, with the advent of returning people to work, the advent of vaccines and returning people to work, there's a huge disconnect between people's views and opinions in connection with the pandemic in the first place, whether they believe it to actually be a public health crisis or something else. With respect to vaccines, the efficacy of the vaccines, the legitimacy of the vaccines in the first place, and then whether or not the government or an employer has the right to mandate that they be vaccinated to work, and even all the way down to masking in the workplace has become a very hot topic, where we deal with clients who have employees who are getting into huge arguments and shouting matches over whether or not masks are required. You've probably seen it in the news. We've seen violence in a lot of workplaces that are open to the public, Starbucks and other retail establishments, where employees are actually getting threatened, or worse yet, abused by customers because they're asking them to wear their masks. I don't know if you guys saw in the news about a month and a half ago, a Southwest flight attendant was attacked by a passenger. That passenger apparently is from around here somewhere, the Sacramento region. And when the flight attendant was enforcing the federal masking rule on airplanes, she was punched and 2 of her teeth were knocked out and she had blood coming down her face. It was videoed by another passenger. So these are really unprecedented times we're in. As Ryan said, we're seeing a lot more employees who are struggling with mental health issues, just dealing with kind of the pressure and weight of the pandemic and what it's done to their lifestyle and their work or lack of work. And it's created a very volatile environment in certain cases. And so just like the obligations to prevent violence under OSHA and federal OSHA in connection with other hot topic issues, the same is true with respect to any issues related to COVID-19. Same with harassment. While being an anti-vaxxer is not a protected class under federal and state law, and we do have guidance from both the EEOC and the DFEH with respect to an employer's rights with respect to vaccines in the workplace. There are, people peddling on the internet that if you don't believe in vaccines, that's a protected class and your employer can't take any employment action against you on that basis. That is just fundamentally not supported by current law. However, there are certain disability and medical conditions and sincerely held religious beliefs that do provide certain protections to employees, including potentially not having to get vaccinated. However, those are individualized assessments that the employer has to engage in on a case-by-case basis and engage in the interactive process with that individual to determine what their current situation is, what their medical or disability is, and or their sincere religious belief, to determine whether it can be accommodated without it creating an undue hardship for the employer or creating without creating a direct threat of health and safety to others in the workplace. And not to get too far off task, but there's a belief that just turning in a religious exemption request means no vaccine and I can walk the halls and do whatever I want because I have a religious exemption. That is not true. The exemption request triggers the obligation for the employer and the employee to engage in the interactive process to see if there's some alternative to the vaccine that can still help the employee do their job and also protect the health and safety of other workers. So it doesn't mean free range in the workplace, but it may mean remote work if the job is conducive to remote work. It may mean regular testing each week to ensure they're not infected with COVID-19. It may mean readjustment of work location or non-essential duties to other areas so that they're not in contact with people and so forth. So this is a big area right now, but we are seeing a lot of volatility around it. People are, we get the sense that people are agitated when they're trying to request these exemptions. And oftentimes there's more to it than a disability or religious belief, but a real distrust of government and all of the mandates that are going out because of the pandemic. So comply with your obligations under Cal-OSHA, which has emergency standards regarding to COVID-19, comply with Cal-OSHA and OSHA's violence prevention standards, comply with your obligations to protect against harassment, and then comply with hopefully your policies and the law to ensure employees understand they shouldn't bully or abuse people because of differences in belief in connection with COVID-19. Okay, what are some steps, some practical steps for employers to prevent bullying in the workplace? It is not mandated that you have an anti-bullying policy in your handbook. For example, you should have a harassment and discrimination prevention policy in your handbook, and the DFEH has rules on what that policy should contain. But we recommend that you have a standards of conduct and an anti-bullying policy in your handbook. Therefore, it's transparent for your employees, and there's no question about what the expectations are of the employer with respect to employees' conduct and interaction with one another. And then, of course, always promote respectful and professional communication between all employees, regardless of level, right? Regardless of level. It doesn't matter if you're the CEO or if you're the night janitor at a company. You should have, you should be able to come to work and be respected for who you are. You obviously meet expectations, but you should not be bullied and treated poorly merely because of your position at the company. Train employees on anti-bullying. You're required to do that in California under AB 2053. That bill came out after AB 1825, the first bill that came out for supervisor anti-harassment training. But as most of you on the webinar know, since that bill, we've had a number of other laws where not only do we train our supervisors every 2 years, but we also have to train our rank and file non-supervisors every 2 years as well. And part of that training should also include a component on abusive conduct and anti-bullying under AB 2053. Take reports of alleged misconduct seriously, whether or not you believe them to violate a policy or worse yet, the law, or if you think the person is just a squeaky wheel, take them seriously and look into it. Because we get a lot of clients who say, this is my squeaky wheel in the department. He or she complains about everything. She's come to me again. She's said, you know, John did X, Y, and Z, and I am so tired of her coming to me with everything. She just needs to figure out how to work with, you know, Johnny, whatever his name is. And if you just ignore it and push it back, and it results in some pervasive, continuing type of conduct that escalates beyond bullying, then you're going to find the company is going to be at risk of liability for failure to fulfill its statutory obligations to investigate potential harassment and discrimination in the workplace. So take them seriously, look into it. You may conclude, yeah, it's just another squeaky wheel and this is a personality conflict. But in that case, even if that is happening over and over again, then some intervention needs to take place, right? It may not be that there's been a policy violation, but it may be that this relationship between these two workers needs some mediation, right? Maybe they need some retraining or some one-on-one coaching or, you know, some sort of management training if it's a manager and a subordinate. So it's not always that you're going to take disciplinary action or terminate somebody when you've looked in and need to take remedial action, but you should take some action and then be able to document that you did for two reasons. One, so that you can help have a good work environment and help your employees have a work environment where they can come to work and feel respected and not bullied. But then two, since we also are defense lawyers, is that I want you to have documentation you're taking appropriate steps so that if you get sued, you can show the court that you've taken appropriate steps. And then for the supervisors and managers on the line, you are the ones who, you know, are having more of the one-on-one interactions with these employees or witnessing your employees' interactions with each other. And you need to also be mindful that bullying should not be happening in your workplace. And surely harassment and discrimination should not, or threats or actual acts of violence. So, you know, one thing I always want to caution supervisors and managers on is that when you're speaking with someone engaged or what you perceive to be, you know, aggressive or bullying conduct, remain objective about it. Focus on what it is you saw or observed or were told if somebody reported it to you. And try not to make assumptions or pass judgment about why the person is engaging in the aggressive or bullying conduct. And more importantly, try not to rationalize it first, right? It's a problem if you go and say, you know, John, I know you're under a lot of stress because you've got time constraints this month. And so when I heard you talking to Julie like that and yell at her, I'm sure that's why you were doing it. But, you know, let's try not to do that again because we don't want you yelling at Julie. Well, when you go in with that approach, you essentially are softening or rationalizing John's reasoning for yelling. And that should not be the focus, because for some bullies, that lets them know that you understand their way of communication and you're going to let them do it. It's better to go in and focus on the conduct first and then say, and I give you an example, I have some concerns about how you spoke to Julie in the meeting yesterday. When you said XYZ, your tone was somewhat aggressive. As you know, our company, our organization doesn't allow bullying and that kind of talk, and I want to talk to you about it. Now, at that point, John may tell you, oh yeah, I did yell at Julie. I'm so frustrated because I'm under these deadlines this month. And, she's not working fast enough. Well, then you get that information from John, and then you may need to take some other action, right? You may need to tell John, oh, okay, we'll get you another person to help with Julie, or we'll talk with Julie and see what the delay is. But you would say to John, I understand your frustration, but you can't express it that way. You can't treat Julie that way because of your frustration. We have to find other ways of communication, other ways of alternative means to resolve your frustration. Okay. So, and then of course, remember always for managers and supervisors on the line that you're not in this alone. So if you have HR in your company, consult with HR, rely on HR and or upper management to assist you when you're dealing with really sensitive or difficult issues involving relationships or personal interactions between employees. And then we're going to leave you with this acronym, which I use even in my harassment prevention training that I do for supervisors and non-supervisors. In the interest of full disclosure, I did not create it. I just use it. It was out there in the public sphere. But it's a very, very good acronym about effective communication via respect. And that is, we can reduce a lot of the issues of bullying, harassment, and even perceived or actual threats of violence in the workplace if we resolve conflicts early and collaboratively and get help to do it. Get HR or upper management involved if you need it, somebody who can help mediate with the parties involved. Explore options and alternatives to resolve differences, right? Don't be a dictator. Don't be an all or nothing. Remember how everybody comes to the workplace from different backgrounds. Sensitize yourself to those differences and uniquenesses of others. We're not all the same. Not everybody thinks the same way as I do. I can't expect them to understand everything the same way as I do. Promote positive interaction. Thank you goes a long way. Eliminate unacceptable behavior, right? So even though you may be the stressed manager, take that deep breath and think before you say or do something, before you lose that temper. And that's really important for yourself. And it's also because of the next letter. And that is, when we act as agents of an employer, as agents of a company, we have to consider the company's and employers' needs and interests and all the other people who work for it, as well as our own, right? One, so that people can have a healthy workplace. And two, sometimes our words and conduct can get the employer in trouble. So we need to consider those interests. And then finally, take responsibility for your words and actions, just like thank you goes a long way. So does I'm sorry. And with that, I think we're going to finish right on time. I really appreciate all of you guys joining. Sorry about the little audio problem we had when Ryan was on there for a second. And if there are some questions, we'll check the Q&A. I think most of those are talking about the sound problem. And I just want you to know we do have some upcoming webinars. The next one is on November 3rd. Can you hear that whistle blowing? Exploring the many exploring the many statutory protections against retaliation in the workplace. And then for those of you who need to get your sexual harassment, why isn't my screen working? To get your sexual harassment training in for either your supervisors or non-supervisors, we will be conducting an open training session. That means by registration. This is a pay for services training because it is a statutory training in which the attendees will be certified that they are compliant with state law. And that will be on December 2nd, 9:30 to 10:30 for non-supervisors and supervisors, because there's only 1 hour for non-supervisors. And then the second required hour for supervisors from 10:45 to 11:45. And as you can see, the cost is $50 for supervisors and $25 for non-supervisors. So thank you so much for coming. Don't forget that There will be another e-blast that goes out after the webinar with more information. And if you have any specific legal issues, the labor and employment lawyers here at Weintraub are happy to assist if we can. Reach out to Ryan or me. Thanks so much.
Thank you.
Okay, I think we're good.